State immunity estoppel does not also lie against the government or any of its agencies arising from unauthorized or illegal acts of public officers. Hence, we cannot hold petitioners estopped from invoking their immunity from suit on account of having raised it only for the first time on appeal. The City of Ecology, Future Vision Co. Inc. GR. No. 190,289, January 17, 2018. No consent to be sued and be liable for damages can thus be implied from the mere conferment and exercise of the power to issue business permits and licenses. Accordingly, there is merit in petitioners' argument that they cannot be sued by respondent since the city's consent had not been secured for this purpose. This is notwithstanding petitioners' failure to raise this exculpatory defense at the first instance before the trial court or even before the appellate court. The City of Ecology, Future Vision Co. Inc. GR. No. 190,289, January 17, 2018. Note: it must be emphasized that the nature of bingo operations is a form of gambling. Thus, its operation is a mere privilege which could not only be regulated, but may also very well be revoked or closed down when public interests so require. In this jurisdiction, we adhere to the principle that injury alone does not give respondent the right to recover damages, but it must also have the right of action for the legal wrong inflicted by petitioners. In order that the law will give redress for an act causing damage, there must be done et injuria. That act must be not only hurtful, but wrongful. The City of Ecology, Future Vision Co. Inc. GR. No. 190,289, January 17, 2018. SOLCO theorizes that the California necessarily held the city government of Makati liable for the return of the proceeds of the tax sale to him when it nullified the tax sale proceedings. According to SOLCO, this could not be done without violating the principle of the state's immunity from suit, as the payment he made in the tax sale already formed part of the public funds of the state as taxes, having been paid to answer a delinquent tax, and as such cannot be withdrawn therefrom without a proper appropriation law. SOLCO pointed out, in addition, the importance of taxes as the lifeblood of the government. As expressly stated in Section 267, the amount deposited shall be paid to the purchaser at the auction sale if the deed is declared invalid. Otherwise, it shall be returned to the depositor. In fine, such deposit is meant to reimburse the purchaser of the amount he had paid at the tax sale should the court declare the sale invalid. XXX. With this, there is an assurance that the public fund shall not be made liable whatever may be the outcome of the case. Thus, contrary to SOLCO's contention, the city government of Makati is not an indispensable party in this annulment of title/land registration case, wherein the validity of the tax sale upon which the applicant's claim is grounded is an issue. SOLCO v. Megaworld Corporation, GR. No. 213,669, March 5, 2018. Separation of powers. Verily, this court cannot in the guise of interpretation modify the explicit language of RA. No. 9903 in waiving the collection of accrued penalties to also include claims for refund. It obviously violates the Res Politica principle entrenched in the very fabric of democracy itself. H. Villeri Capone Shop Inc. v. Social Security Commission, GR. No. 228,087, January 24, 2018. In other words, the court cannot review the rules promulgated by Congress in the absence of any constitutional violation. Lagman v. Senate President, GR. No. 235,935, February 6, 2018. Construing the full discretionary power granted to the Congress in promulgating its rules, the court, in the case of Spouses de la Paz Ret. v. Senate Committee on Foreign Relations, et al., explained that the limitation of this unrestricted power deals only with the imperatives of quorum, voting and publication. Lagman v. Senate President, GR. No. 235,935, February 6, 2018. The court's power of review, as provided under Section 18, Article VII, does not empower the court to advise, nor dictate its own judgment upon the President, as to which and how these military powers should be exercised. Lagman v. Senate President, GR. No. 235,935, February 6, 2018. In the same vein, Ordinance No. 092-2000 reflects the wisdom of the Sangguniang Panlungsod as elected representatives of the people of Davao City. In local affairs, acts of local officials must be upheld when it is clear that these were performed squarely within the statutory authority granted to them and in the exercise of their sound discretion. Ivoscovi. Montones, Gr. No. 199,172, February 21, 2018. Without a law to justify its action, the issuance of DOI Circular No. 41 is an unauthorized act of the DOI of empowering itself under the pretext of dire exigency or urgent necessity. This action runs afoul the separation of powers between the three branches of the government and cannot be upheld. Even the Supreme Court, in the exercise of its power to promulgate rules, is limited in that the same shall not diminish, increase, or modify substantive rights. Genuinovi, de Lima, Gr. No. 197930, Arroyovi, de Lima, Gr. No. 199034, Arroyovi, de Lima, Gr. No. 199,046, April 17, 2018. Local Governments Republic Act No. 4354, otherwise known as the Revised Charter of the City of Davao, Davao City Charter, enacted on June 19, 1965, vested the local Sangguniang Panlungsod with the legislative power to regulate, prohibit, and fix license fees for the display, construction, and maintenance of billboards and similar structures. With the aforementioned law, Congress expressly granted the Davao City government, through the Sangguniang Panlungsod, police power to regulate billboard structures within its territorial jurisdiction. Ivoscovi. Montes, Gr. No. 199,172, February 21, 2018. Note. As stated earlier, the power to regulate billboards within its territorial jurisdiction has been delegated by Congress to the city government via the Davao City Charter. This direct and specific grant takes precedence over requirements set forth in another law of general application, in this case the National Building Code. Stated differently, the city government does not need to refer to the procedures laid down in the National Building Code to exercise this power. Thus, the consistency between Ordinance No. 092-2000 with the National Building Code is irrelevant to the validity of the former. To be clear, even if the National Building Code imposes minimum requirements as to the construction and regulation of billboards, the city government may impose stricter limitations because its police power to do so originates from its charter and not from the National Building Code. The ordinance specifically governs billboards and other similar structures situated within Davao City, independent of the provisions of the National Building Code. Ivoscovi. Montes, Gr. No. 199,172, February 21, 2018. Administrative bodies. The court has consistently held that technical rules applicable to judicial proceedings are not exact replicas of those in administrative investigations. Recourse to discovery procedures as sanctioned by the rules of court is then not mandatory for the OGCLSPSP. Hence, we cannot subscribe to Norlina's tenacious insistence for the OGCLSPSP to strictly adhere to the rules of court so as not to purportedly defeat our rights. Sibayan v. Alda, Gr. No. 233,395, January 17, 2018. Thus, the doctrine of primary administrative jurisdiction refers to the competence of a court to take cognizance of a case at first instance. Unlike the doctrine of exhaustion of administrative remedies, it cannot be waived. Republic v. Gallo, Gr. No. 207,074, January 17, 2018. Note. However, for reasons of equity, in cases where jurisdiction is lacking, this court has ruled that failure to raise the issue of non-compliance with the doctrine of primary administrative jurisdiction at an opportune time may bar a subsequent filing of a motion to dismiss based on that ground by way of laches. Republic v. Gallo, Gr. No. 207,074, January 17, 2018. The Chiac Construction Industry Arbitration Commission is a quasi-judicial body exercising quasi-judicial powers. Metro Rail Development Corporation v. Gammon Philippines, Inc., Gr. No. 200,401, January 17, 2018. Note. CHIAC was created under Executive Order No. 1008 to establish an arbitral machinery that will settle expeditiously problems arising from, or connected with, contracts in the construction industry. Its jurisdiction includes construction disputes between or among parties to an arbitration agreement, or those who are otherwise bound by the latter, directly or by reference. Thus, any project owner, contractor, subcontractor, fabricator, or project manager of a construction project who is bound by an arbitration agreement in a construction contract is under CHIAC's jurisdiction in case of any dispute. Metro Rail Development Corporation v. Gammon Philippines, Inc., GR, No. 200,401, January 17, 2018, Note. A quasi-judicial agency is a government body, not part of the judiciary or the legislative branch, which adjudicates disputes and creates rules which affect private parties' rights. It is created by an enabling statute, and thus, its existence continues beyond the resolution of a dispute and is independent from the will of the parties. Its powers are limited to those expressly granted or necessarily implied in the enabling law. Metro Rail Development Corporation v. Gammon Philippines, Inc., GR, No. 200,401, January 17, 2018, Note. Quasi-judicial or administrative adjudicatory power has been defined as the power 1. To hear and determine questions of fact to which legislative policy is to apply, and 2. To decide in accordance with the standards laid down by the law itself in enforcing and administering the same law. Metro Rail Development Corporation v. Gammon Philippines, Inc., GR, No. 200,401, January 17, 2018, Note. Arbitration under a quasi-judicial body is similar to commercial arbitration in that its factual findings are generally accorded respect and finality. However, commercial arbitration is conducted by ad hoc bodies created by stipulation of parties for the purpose of settling disputes concerning their private or proprietary interests. In general, the findings in commercial arbitration are respected to uphold the autonomy of arbitral awards. On the other hand, quasi-judicial agencies were created for a speedier resolution of controversies on matters of state interest that require specialized knowledge and expertise. Metro Rail Development Corporation v. Gammon Philippines, Inc., GR, No. 200,401, January 17, 2018. Note. Initially, CHIAC decisions are appealable only to this court. However, when the rules of court were enacted, appeals from CHIAC decisions became appealable to the Court of Appeals under Rule 43. Metro Rail Development Corporation v. Gammon Philippines, Inc., GR, No. 200,401, January 17, 2018. The SSS through the SSC is empowered to issue the necessary rules and regulations for the effective implementation of RA No. 9903. Quasi-legislative power is exercised by administrative agencies through the promulgation of rules and regulations within the confines of the granting statute and the doctrine of non-delegation of powers from the separation of the branches of the government. H. V. Larry Capone Shop, Inc., v. Social Security Commission, GR, No. 228,087, January 24, 2018. Until and unless declared invalid in a proper case, the basic formulas contained in our administrative orders partake of the nature of statutes. XXX Land Bank of the Philippines v. Alcantara, GR, No. 187,423, February 28, 2018. Indeed, non-ICCS/IPS cannot be subjected to the special and limited jurisdiction of the NCIP even if the dispute involves rights of ICCS/IPS, since the NCIP has no power and authority to decide on a controversy involving rights of non-ICCS/IPS, which should be brought before the courts of general jurisdiction within the legal bounds of rights and remedies. Plainly, contrary to the Court Quo's conclusion, this case cannot be subjected to the NCIP's jurisdiction as respondents are clearly non-ICCS/IPS. Heirs of Tunj v. Stop Lush Realty and Development, Inc., GR, No. 231,737, March 6, 2018. Bangkok Central's Monetary Board is a quasi-judicial agency. Its decisions, resolutions, and orders are the decisions, resolutions, and orders of a quasi-judicial agency. Any action filed against the Monetary Board is an action against a quasi-judicial agency. This does not mean, however, that Banco Central only exercises quasi-judicial functions. As an administrative agency, it likewise exercises powers and/or functions which may be characterized as administrative, investigatory, regulatory, quasi-legislative, or quasi-judicial, or a mix of these five, as may be conferred by the Constitution or by statute. Banco Filipino Savings and Mortgage Bank v. Banco Central en Pilipinas, Gr. No. 200,678, June 4, 2018. Note: as previously discussed, Respondent Banco Central exercises a myriad of functions, including those that may not be necessarily exercised by a quasi-judicial agency. It is settled, however, that it exercises its quasi-judicial functions through Respondent Monetary Board. Any petition for certiorari against an act or omission of Banco Central, when it acts through the Monetary Board, must be filed with the Court of Appeals. Banco Filipino Savings and Mortgage Bank v. Banco Central en Pilipinas, Gr. No. 200,678, June 4, 2018. National Territory. The information categorically alleged that the incident happened along the riverbank of Brgy, San Roque, Municipality of Villarreal, Province of Samar. Under Section 2A of PD 532, Philippine waters is defined as follows: ALL bodies of water, such as but not limited to seas, gulfs, bays around, between and connecting each of the islands of the Philippine archipelago, irrespective of its depth, breadth, length or dimension, and all other waters belonging to the Philippines by historic or legal title, including territorial sea, the seabed, the insular shelves, and other submarine areas over which the Philippines has sovereignty or jurisdiction. From this definition, it is clear that a river is considered part of Philippine waters. People v. Dela P.A. Gr. No. 219,581, January 31, 2018. Social justice. To this end, the Court upholds and abides by this canon of interpretation against applicants of the benefits of RA. No. 9903 as a recognition to the constitutional policies of freeing the people from poverty through policies that provide adequate social services and affording full protection to labor. It is consistent with the congressional intent of placing a primary importance in helping the SSS increase its funds through stimulating cash inflows by encouraging delinquent employers to settle their accountabilities. Thus, RA. No. 9903 shall be understood as not to include a refund of penalties paid before its effectivity. H. Villari Capon Shop, Inc. v. Social Security Commission, Gr. No. 228,087, January 24, 2018. The Court has reiterated that a policy of social justice is not intended to countenance wrongdoing simply because it is committed by the underprivileged. At best, it may mitigate the penalty, but it certainly will not condone the offense. Compassion for the poor is an imperative of every humane society, but only when the recipient is not a rascal claiming an undeserved privilege. Social justice cannot be permitted to be a refuge of scoundrels any more than can equity be an impediment to the punishment of the guilty. Those who invoke social justice may do so only if their hands are clean and their motives blameless, and not simply because they happen to be poor. This great policy of our Constitution is not meant for the protection of those who have proved they are not worthy of it, like the workers who have tainted the cause of labor with the blemishes of their own character. Central Azucar Radibes v. Heirs of Zulu Apostol, Gr. No. 215,314, March 14, 2018. Youth necessarily, herein minor appellants shall be entitled to appropriate disposition under Section 51, RA. No. 9344, which extends even to one who has exceeded the age limit of 21 years, so long as he committed the crime when he was still a child, and provides for the confinement of convicted children. People v. Sisrocan, Gr. No. 226,494, February 14, 2018. We note, however, that FFF, being a minor at the time of the commission of the offense, should benefit from a suspended sentence pursuant to Section 38 of RA 9344, or the Juvenile Justice and Welfare Act of 2006. People v. Lobabo, Gr. No. 234651, June 6, 2018. Women by enacting the Constitution and signing on the SALN, the state has committed to ensure and to promote gender equality. In 2009, Congress enacted Republic Act No. 9710 or the Magna Carta for Women, which provides that the state shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations. This necessarily includes the second paragraph of Article 26 of the Family Code. Thus, Article 26 should be interpreted to mean that it is irrelevant for courts to determine if it is the foreign spouse that procures the divorce abroad. Once a divorce decree is issued, the divorce becomes validly obtained and capacitates the foreign spouse to marry. The same status should be given to the Filipino spouse. The national law of Japan does not prohibit the Filipino spouse from initiating or participating in the divorce proceedings. It would be inherently unjust for a Filipino woman to be prohibited by her own national laws from something that a foreign law may allow. Parenthetically, the prohibition on Filipinos from participating in divorce proceedings will not be protecting our own nationals. Racho v. Tanaka, Gr. No. 199515, June 25, 2018. Ecology. Our legislators saw the need for a concerted effort of the government and society to abate, control, and prevent the pollution of our country's water resources. Hence, the Clean Water Act was enacted in the hope that this vital measure will offer the future generation an abundant supply of potable water, clean rivers to swim in, and a better access to safe water for their daily use. Republic v. N. D. Lomer Stampers and Sons, Inc., Gr. No. 201501, January 22, 2018. Given that the writ of Calicosin is an extraordinary remedy and the RPEC allows direct action to this court and the California where it is dictated by public welfare, this court is of the view that the prior 30-day notice requirement for citizen suits under RA 9003 and RA 8749 is inapplicable. It is ultimately within the court's discretion whether or not to accept petitions brought directly before it. Osmivi, Garganera, Gr. No. 231164, March 20, 2018. Labor. When the evidence in labor cases is inequitous, doubt is resolved in favor of the employee. Hubila v. Xi Marketing Ltd. Co. Gr. No. 207354, January 10, 2018. Note: where both parties in a labor case have not presented substantial evidence to prove their allegations, the evidence is considered to be inequitous. In such a case, the scales of justice are tilted in favor of labor. Thus, petitioners are hereby considered to have been illegally dismissed. Hubila v. Xi Marketing Ltd. Co. Gr. No. 207354, January 10, 2018. Laws in this regard. It must be said that there is no merit in the contention of petitioner that the amendment introduced by RA No. 9700 cannot be applied retroactively in the case at bar. Primarily, a cursory reading of the provision readily reveals that Section 19 of RA No. 9700 merely highlighted the exclusive jurisdiction of the DAR to rule on agrarian cases by adding a clause which mandates the automatic referral of cases upon the existence of the requisites therein stated. Simply, RA No. 9700 does not deviate but merely reinforce the jurisdiction of the DAR set forth under Section 50 of RA No. 6657. Moreover, in the absence of any stipulation to the contrary, as the amendment is essentially procedural in nature, it is deemed to apply to all actions pending and undetermined at the time of its passage. Chale's Development Company, Inc. v. Dizon, Gr. No. 206788, February 14, 2018. Parliamentary immunity. Petitioner admits that he uttered the questioned statements, describing private respondent as former VP Binay's front or dummy in connection with the so-called Hacienda Binay in response to media interviews during gaps and breaks in plenary and committee hearings in the Senate. With Jimenez as our guidepost, it is evident that petitioner's remarks fall outside the privilege of speech or debate under Section 11, Article VI of the 1987 Constitution. The statements were clearly not part of any speech delivered in the Senate or any of its committees. They were also not spoken in the course of any debate in said fora. It cannot likewise be successfully contended that they were made in the official discharge or performance of petitioner's duties as a senator, as the remarks were not part of or integral to the legislative process. Trillanes v. Castillo Mergoman, Gr. No. 223451, March 14, 2018, citing Jimenez v. Kabang Bang, 124 Phil, 1961-966, note. To participate in or respond to media interviews is not an official function of any lawmaker. It is not demanded by his sworn duty, nor is it a component of the process of enacting laws. Indeed, the lawmaker may well be able to discharge his duties and legislate without having to communicate with the press. The lawmaker's participation in media interviews is not a legislative act, but is political in nature outside the ambit of the immunity conferred under the speech or debate clause in the 1987 Constitution. Contrary to petitioner's stance, therefore, he cannot invoke parliamentary immunity to cause the dismissal of private respondent's complaint. The privilege arises not because the statement is made by a lawmaker, but because it is uttered in furtherance of legislation. Trillanes v. Castillo Mergoman, Gr. No. 223451, March 14, 2018. Appropriations. The petitioners contended that the implementation of the MVPSP using the funds allocated under the item MFO2, Motor Vehicle Registration and Driver's Licensing Regulatory Services, was unconstitutional because the item constituted a lump sum appropriation that undermined the exercise by the President of his veto power under Article VI, Section 27(2) of the Constitution. Under the system of performance-informed budgeting, the PAPs are grouped or aligned into the major final outputs MFOS. However, the groupings do not mean that there are no longer any line items. As explained in Belgica v. Executive Secretary, line items under appropriations should be specific appropriations of money that will enable the President to discernibly veto the same, to wit. An item, as defined in the field of appropriations, pertains to the particulars, the details, the distinct and severable parts of the appropriation or of the bill. In the case of Bengkazan v. Secretary of Justice of the Philippine Islands, the US Supreme Court characterized an item of appropriation as follows. An item of an appropriation bill obviously means an item which, in itself, is a specific appropriation of money, not some general provision of law which happens to be put into an appropriation bill. On this premise, it may be concluded that an appropriation bill, to ensure that the President may be able to exercise his power of item veto, must contain specific appropriations of money and not only general provisions which provide for parameters of appropriation. Further, it is significant to point out that an item of appropriation must be an item characterized by singular correspondence, meaning an allocation of a specified singular amount for a specified singular purpose, otherwise known as a line item. This treatment not only allows the item to be consistent with its definition as a specific appropriation of money, but also ensures that the President may discernibly veto the same. Dela Cruz v. Ochoa, Gr. No. 219683, January 23, 2018, note. In Arolo v. Aquino III, the court has expounded the term item as the last and indivisible purpose of a program in the appropriation law, which is distinct from the expense category or allotment class. Dela Cruz v. Ochoa, Gr. No. 219683, January 23, 2018. The petitioner's contention that the MFO2 constituted a lump sum appropriation had no basis. The specific appropriations of money were still found under details of the FY 2014 budget, which was attached to the 2014 GAO. They specified and contained the authorized budgetary programs and projects under the GAO XXX. As gleaned from the details of the FY 2014 budget, the MFOS constituted the expense category or class, while the last and indivisible purpose of each program under the MFOS were enumerated under the details of the FY 2014 budget. In particular, the specific purpose provided under the MFO2 was an appropriation for a motor vehicle registration system. Such specific purpose satisfied the requirement of a valid line item that the President could discernibly veto. Dela Cruz v. Ochoa, Gr. No. 219683, January 23, 2018, note. In Jacamil v. Aboya, the court, upholding the legality of the procurement of the MVPSP, opined that whatever defect had attended its procurement were cured by the appropriation for the full amount of the project under the 2014 GAO. Dela Cruz v. Ochoa, Gr. No. 219,683, January 23, 2018. To explain, Section 29(1), Article VI of the 1987 Constitution ordains that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. The only exception is found in Section 25(5), Article VI of the 1987 Constitution, by which the President of the Philippines, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Philippines, and the heads of the constitutional commissions are authorized to transfer appropriations to augment any item in the GAO for their respective offices from the savings in other items of their respective appropriations. The CASP is definitely not among the officials or agencies authorized to transfer their savings in other items of its appropriation. The CASP came into being by virtue of Presidential Decree No. 1 on September 1, 1974. The CASP, although intended to be an autonomous entity, is administratively attached to the Civil Service Commission (CSC) and does not wield the power to authorize the augmentation of items of its appropriations from savings in other items of its appropriations. With the CSC being the office vested with fiscal autonomy by the 1987 Constitution, the CASP's use of its savings to cover the CNA benefits for its employees had no legal basis. Career Executive Service Board v. Commission on Audit, Gr. No. 212,348, June 19, 2018. Tax exemptions. Lastly, while tax exemptions are strictly construed against the taxpayer, the government should not misuse technicalities to keep money it is not entitled to. Philippine Airlines v. Commissioner of Internal Revenue, Gr. Nos. 20607980, January 17, 2018. While tax amnesty is in the nature of a tax exemption, which is strictly construed against the taxpayer, the court cannot disregard the plain text of RA No. 9480. Commissioner of Internal Revenue v. Coventry Energy Philippine Holdings, Inc., Gr. No. 203,160, January 24, 2018. Note: considering that SEFI completed the requirements and paid the corresponding amnesty tax, it is considered to have totally complied with the tax amnesty program. As a matter of course, SEFI is entitled to the immediate enjoyment of the immunities and privileges of the tax amnesty program. Nonetheless, the court emphasizes that the immunities and privileges granted to taxpayers under RA No. 9480 is not absolute. It is subject to a resolutory condition insofar as the taxpayer's enjoyment of the immunities and privileges of the law is concerned. These immunities cease upon proof that they underdeclare their net worth by 30%. Commissioner of Internal Revenue v. Coventry Energy Philippine Holdings, Inc., Gr. No. 203,160, January 24, 2018. Presidential immunity. Presidential privilege of immunity from suit is a well-settled doctrine in our jurisprudence. The President may not be sued during his tenure or actual incumbency, and there is no need to expressly grant such privilege in the Constitution or law. This privilege stems from the recognition of the President's vast and significant functions which can be disrupted by court litigations. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Note: it is, thus, clear that petitioners in Gr. Nos. 236,061 and 236,145 committed a procedural misstep in including the President as a respondent in their petitions. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Military powers. The determination of which among the constitutionally given military powers should be exercised in a given set of factual circumstances is a prerogative of the President. The court's power of review, as provided under Section 18, Article VII, does not empower the court to advise, nor dictate its own judgment upon the President, as to which and how these military powers should be exercised. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Note: Congressional check on the President's martial law and suspension powers thus consists of: first, the power to review the President's proclamation of martial law or suspension of the privilege of the writ of habeas corpus, and to revoke such proclamation or suspension. The review is automatic in the sense that it may be activated by Congress itself at any time after the proclamation or suspension is made. The Congress decision to revoke the proclamation or suspension cannot be set aside by the President. Second, the power to approve any extension of the proclamation or suspension upon the President's initiative, for such period as it may determine, if the invasion or rebellion persists and public safety requires it. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. When approved by the Congress, the extension of the proclamation or suspension, as described during the deliberations on the 1987 Constitution, becomes a joint executive and legislative act or a collective judgment between the President and the Congress. XXX. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. The provision is indisputably silent as to how many times the Congress, upon the initiative of the President, may extend the proclamation of martial law or the suspension of the privilege of habeas corpus. Such silence, however, should not be construed as a vacuum, flaw or deficiency in the provision. While it does not specify the number of times that the Congress is allowed to approve an extension of martial law or the suspension of the privilege of the writ of habeas corpus, Section 18, Article VII is clear that the only limitations to the exercise of the congressional authority to extend such proclamation or suspension are that the extension should be upon the President's initiative, that it should be grounded on the persistence of the invasion or rebellion and the demands of public safety, and that it is subject to the court's review of the sufficiency of its factual basis upon the petition of any citizen. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Section 18, Article VII did not also fix the period of the extension of the proclamation and suspension. However, it clearly gave the Congress the authority to decide on its duration. Thus, the provision states that the extension shall be for a period to be determined by the Congress if it were the intention of the framers of the Constitution to limit the extension to 60 days, as petitioners in Gr. No. 235935 theorize. They would not have expressly vested in the Congress the power to fix its duration. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Note: the information upon which the extension of martial law or of the suspension of the privilege of the writ of habeas corpus shall be based principally emanate from and are in the possession of the Executive Department. Thus, the court will have to rely on the fact-finding capabilities of the Executive Department. In turn, the Executive Department will have to open its findings to the scrutiny of the court. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Note: the requirement of the Constitution is therefore adequately met when there is sufficient factual basis to hold that the present and past acts constituting the actual rebellion are of such character that endanger and will endanger public safety. This permissive approach is sanctioned not only by an acknowledgement that the Congress is and should be allowed flexibility, but also because the court is without the luxury of time to determine accuracy and precision. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. Martial law is a law of necessity. Necessity creates the conditions for martial law and at the same time limits the scope of martial law. Thus, when the need for which Proclamation No. 216 was further extended no longer exists, the President can lift the martial law imposition even before the end of the one-year period. Under the same circumstances, the Congress itself may pass a resolution pre-terminating the extension. This power emanates from Congress authority, granted under the Constitution, to approve the extension and to fix its duration. The power to determine the period of the extension necessarily includes the power to shorten it. Furthermore, considering that this court's judgment on the constitutionality of an extension is transitory or valid at that certain point of time, any citizen may petition the court to review the sufficiency of the factual basis for its continued implementation should the President and the Congress fail or refuse to lift the imposition of martial law. Lagman v. Senate President, Gr. No. 235935, February 6, 2018. Judicial Power Section 1, Article VII of the Constitution pertains to the court's judicial power to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The first part is to be known as the traditional concept of judicial power, while the latter part, an innovation of the 1987 Constitution, became known as the court's expanded jurisdiction. Under its expanded jurisdiction, courts can now delve into acts of any branch or instrumentality of the government traditionally considered as political if such act was tainted with grave abuse of discretion. Lagman v. Senate President, Gr. No. 235935, February 6, 2018. Hence, the court concluded that a petition for certiorari pursuant to Section 1 or Section 5 of Article VII is not the proper tool to review the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. We held that to apply the standard of review in a petition for certiorari will emasculate the court's constitutional task under Section 18, Article VII, which was precisely meant to provide an additional safeguard against possible martial law abuse and limit the extent of the powers of the Commander-in-Chief. Lagman v. Senate President, Gr. No. 235935, February 6, 2018. Note: with regard to the extension of the proclamation of martial law or the suspension of the privilege of the writ, the same special and specific jurisdiction is vested in the court to review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis thereof. Necessarily, and by parity of reasoning, a certiorari petition invoking the court's expanded jurisdiction is not the proper remedy to review the sufficiency of the factual basis of the Congress extension of the proclamation of martial law or suspension of the privilege of the writ. Lagman v. Senate President, Gr. No. 235935, February 6, 2018. Furthermore, as in the case of the court's review of the President's proclamation of martial law or suspension of the privilege of the writ, the court's judicial review of the Congress extension of such proclamation or suspension is limited only to a determination of the sufficiency of the factual basis thereof. By its plain language, the Constitution provides such scope of review in the exercise of the court's sui generis authority under Section 18, Article VII, which is principally aimed at balancing or curtailing the power vested by the Constitution in the Congress to determine whether to extend such proclamation or suspension. Lagman v. Senate President, Gr. No. 235935, February 6, 2018. AC No. 58 to 2003 is an implementation of Section 42 of BP, BLG 129, or the basic provision on longevity pay granted by law to justices and judges in the judiciary. Section 42 of BP, BG 129 is intended to recompense justices and judges for each 5-year period of continuous, efficient, and meritorious service rendered in the judiciary. The purpose of the law is to reward long service, from the lowest to the highest court in the land, XXX. On the other hand, AC No. 58/2003 was issued by this court pursuant to its constitutional power to interpret laws and, as such, has the force and effect of law. In crafting the circular, the court duly considered the long-standing policy of according liberal construction to retirement laws covering government personnel. Re. Application for optional retirement under Republic Act No. 910, as amended by Republic Act No. 5095 and Republic Act No. 9946 of Associate Justice Martin S. Vilrema, Jr. AM, No. 15th 11th 1st SC, March 6, 2018. Jurisdiction Section 5, Article VII of the Constitution, in part, provides that the Supreme Court shall exercise original jurisdiction over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. This court, the Court of Appeals and the regional trial courts have concurrent jurisdiction to issue the extraordinary writs, including quo warranto. Relatedly, Section 7, Rule 66 of the Rules of Court provides that the venue of an action for quo warranto, when commenced by the Solicitor General, is either the Regional Trial Court in the City of Manila, in the Court of Appeals, or in the Supreme Court. Republic v. Sereno, Gr. No. 237428, May 11, 2018. The Court reaffirms its authority to decide the instant quo warranto action. This authority is expressly conferred on the Supreme Court by the Constitution under Section 5, Article VIIXXX. Section 5 of Article VIII does not limit the Court's quo warranto jurisdiction only to certain public officials, or that excludes impeachable officials therefrom. XXX. The Constitution defines judicial power as a duty to be performed by the courts of justice. Thus, for the court to repudiate its own jurisdiction over this case would be to abdicate a constitutionally imposed responsibility. Republic v. Sereno, Gr. No. 237428, Resolution on the motion for reconsideration, June 19, 2018. Note: the court's quo warranto jurisdiction over impeachable officers also finds basis in paragraph 7, section 4, article VII of the Constitution, which designates it as the sole judge of the qualifications of the President and Vice President, both of whom are impeachable officers. With this authority, the remedy of quo warranto was provided in the rules of the court sitting as the Presidential Electoral Tribunal Pet. Republic v. Sereno, Gr. No. 237428, Resolution on the motion for reconsideration, June 19, 2018. With the enactment of R.A. No. 1125, the CTA Court of Tax Appeals was granted the exclusive appellate jurisdiction to review by appeal all cases involving disputed assessments of internal revenue taxes, customs duties, and real property taxes. In general, it has jurisdiction over cases involving liability for payment of money to the government or the administration of the laws on national internal revenue, customs, and real property. Steel Corporation of the Philippines v. Bureau of Customs, Gr. No. 220502, February 12, 2018. A petition for certiorari is the proper remedy to challenge the constitutionality of Sec. 8.3 of R.A. No. 6770. Ifung v. Carpio Morales, Gr. No. 232131, April 24, 2018. Note: clear from his petition was that the petitioner beseeches the court for a declaration primarily as to the unconstitutionality of Sec. 8.3 in relation to Sec. 7 of R.A. No. 6770, and as a consequence thereof, a pronouncement that the incumbent ombudsman and the deputies are de facto officers and whose offices are vacant. The petition does not task the court to scrutinize the qualifications of the respondents to hold office as ombudsman and deputies, but rather to determine the constitutionality of Sec. 8.3 of R.A. No. 6770 insofar as their term of office is concerned. Ifung v. Carpio Morales, Gr. No. 232131, April 24, 2018. In Matting Industrial and Commercial Corporation v. Cars 647 Phil 32421010. This court stated that jurisdiction over intracorporate disputes involving the illegal dismissal of corporate officers was with the Regional Trial Court, not with the labor arbiter. Malcoba v. PreHealth Pharma Philippines, Inc., Gr. 209085, June 6, 2018. When a tax case is pending on appeal with the Court of Tax Appeals, the Court of Tax Appeals has the exclusive jurisdiction to enjoin the levy of taxes and the auction of the taxpayers' properties in relation to that case. Philippine Ports Authority v. The City of Davao, Gr. No. 190324, June 6, 2018. Note: in this case, the Court of Tax Appeals had jurisdiction over petitioner's appeal to resolve the question of whether or not it was liable for real property tax. To recall, the real property tax liability was the very reason for the acts which petitioner wanted to have enjoined. It was, thus, the Court of Tax Appeals, and not the Court of Appeals, that had the power to preserve the subject of the appeal, to give effect to its final determination, and, when necessary, to control auxiliary and incidental matters and to prohibit or restrain acts which might interfere with its exercise of jurisdiction over petitioner's appeal. Thus, respondent acts carried out pursuant to the imposition of the real property tax were also within the jurisdiction of the Court of Tax Appeals. Philippine Ports Authority v. The City of Davao, Gr. No. 190,324, June 6, 2018. Note: even if the law had vested the Court of Appeals with jurisdiction to issue injunctive relief in real property tax cases such as this, the Court of Appeals was still correct in dismissing the petition before it. Once a court acquires jurisdiction over a case, it also has the power to issue all auxiliary writs necessary to maintain and exercise its jurisdiction, to the exclusion of all other courts. Thus, once the Court of Tax Appeals acquired jurisdiction over petitioner's appeal, the Court of Appeals would have been precluded from taking cognizance of the case. Philippine Ports Authority v. The City of Davao, Gr. No. 190,324, June 6, 2018. Requisites for judicial inquiry. We note at the outset that Delamere & Sons attempt to assail the constitutionality of Sec. 28 of RA 9275 constitutes a collateral attack. This is contrary to the rule that issues of constitutionality must be pleaded directly. Unless law is annulled in a direct proceeding, the legal presumption of the law's validity remains. Republic v. N. Delamere & Sons, Inc., Gr. No. 201,501, January 22, 2018. Note: nevertheless, even if the issue of constitutionality was properly presented, Delamere & Sons still failed to satisfy the fourth requisite for this court to undertake a judicial review. Specifically, the issue of constitutionality of Sec. 28 of RA 9275 is not the lis motu of this case. The lis motu requirement means that the petitioner who questions the constitutionality of the law must show that the case cannot be resolved unless the disposition of the constitutional question is unavoidable. Consequently, if there is some other ground, i.e., a statute or law, upon which the court may rest its judgment, that course should be adopted and the question of constitutionality avoided. In this case, Delamere & Sons failed to show that the case cannot be legally resolved unless the constitutional issue it has raised is resolved. Hence, the presumption of constitutionality of Sec. 28 of RA 9275 stands. Republic v. N. Delamere & Sons, Inc., Gr. No. 201,501, January 22, 2018. In these consolidated petitions, petitioners are questioning the constitutionality of a congressional act, specifically the approval of the President's request to extend martial law in Mindanao. Petitioners in Gr. No. 235,935 and 236,155 have also put in issue the manner in which the Congress deliberated upon the President's request for extension. Clearly, therefore, it is the Congress as a body, and not just its leadership, which has interest in the subject matter of these cases. Consequently, it was procedurally incorrect for petitioners in Gr. Nos. 235935, 236,061 and 236,155 to implead only the Senate President and the House Speaker among the respondents. Lagman v. Senate President, Gr. No. 235,935, February 6, 2018. While the lack of jurisdiction of the court may be raised at any stage of an action, nevertheless, the party raising such question may be stopped if he has actively taken part in the very proceedings which he questions and he only objects to the court's jurisdiction because the judgment or the order subsequently rendered is adverse to him. Specified Contractors and Development, Inc. v. Pabocan, Gr. No. 212,472, January 11, 2018. Hierarchy of courts. While the hierarchy of courts serves as a general determinant of the appropriate form for petitions for the extraordinary writs, a direct invocation of the Supreme Court's original jurisdiction to issue such writs is allowed when there are special and important reasons therefor, clearly and specifically set out in the petition. In the instant case, direct resort to the court is justified considering that the action for quo warranto questions the qualification of no less than a member of the court. The issue of whether a person usurps, intrudes into, or unlawfully holds or exercises a public office is a matter of public concern over which the government takes special interest, as it obviously cannot allow an intruder or impostor to occupy a public position. Republic v. Sereno, Gr. 237428, May 11, 2018. Petitioners direct resort to this court, instead of to the Court of Appeals for intermediate review as sanctioned by the rules, violates the principle of hierarchy of courts, XXX. Nonetheless, the doctrine of hierarchy of courts is not inviolable, and this court has provided several exceptions to the doctrine. One of these exceptions is the exigency of the situation being litigated. Here, the controversy between the parties has been dragging on since 2010, which should not be the case when the initial dispute and ejectment case is, by nature and design, a summary procedure and should have been resolved with expediency. Intramuros Administration v. Offshore Construction Development Company, Gr. No. 196795, March 7, 2018, Note. Moreover, this court's rules of procedure permit the direct resort to this court from a decision of the regional trial court upon questions of law, such as those which petitioner raises in this case. Intramuros Administration v. Offshore Construction Development Company, Gr. No. 196795, March 7, 2018. Rule-making authority. It is true that initially, the changes that may be corrected under the summary procedure of Rule 108 of the Rules of Court are clerical or harmless errors. Errors that affect the civil status, citizenship or nationality of a person are considered substantial errors that were beyond the purview of the rule. Republic v. Type A, Gr. No. 209527, February 14, 2018, Note. RA, No. 9048 defined a clerical or typographical error as a mistake committed in the performance of clerical work, which is harmless and immediately obvious to the understanding. It was further amended in 2011, when RA, No. 10172 was passed to expand the authority of local civil registrars and the Consul General to make changes in the day and month in the date of birth, as well as in the recorded sex of a person when it is patently clear that there was a typographical error or mistake in the entry. Unfortunately, however, when Virgil filed the petition for correction with the RTC in 2009, RA, No. 10172 was not yet in effect. As such, to correct the erroneous gender and date of birth in Virgil's birth certificate, the proper remedy was to commence the appropriate adversarial proceedings with the RTC, pursuant to Rule 108 of the Rules of Court. The changes in the entries pertaining to the gender and date of birth are indisputably substantial corrections, outside the contemplation of a clerical or typographical error that may be corrected administratively. Republic v. Type A, Gr. No. 209527, February 14, 2018. To emphasize, the distinction in criminal law is this. Substantive law is that which declares what acts are crimes and prescribes the punishment for committing them, as distinguished from the procedural law which provides or regulates the steps by which one who commits a crime is to be punished. Based on the above, it may be gleaned that the chain of custody rule is a matter of evidence and a rule of procedure. It is therefore the court who has the last say regarding the appreciation of evidence. People v. 10 Molar Y. Adam, Gr. No. 200206, March 5, 2018. Note. The power to promulgate rules concerning pleading, practice and procedure in all courts is a traditional power of this court. This includes the power to promulgate the rules of evidence. On the other hand, the rules of evidence are provided in the rules of court issued by the Supreme Court. However, the chain of custody rule is not found in the rules of court. Section 21 of Republic Act No. 9165 was passed by the Legislative Department and its implementing rules were promulgated by PDEA in consultation with the Department of Justice (DOI) and other agencies under and within the Executive Department. People v. 10 Molar Y. Adam, Gr. No. 200206, March 5, 2018. Note. XXX. The court's power to promulgate judicial rules, including rules of evidence, is no longer shared by the court with Congress. XXX. The chain of custody rule is a matter of evidence and a rule of procedure, and that the court has the last say regarding the appreciation of evidence. Evidentiary matters are indeed well within the powers of courts to appreciate and rule upon, and so, when the courts find appropriate, substantial compliance with the chain of custody rule as long as the integrity and evidentiary value of the seized items have been preserved may warrant the conviction of the accused. People v. Tengmoner Y. Adam, Gr. No. 202,206, March 5, 2018, cited in People v. Saipan, Gr. No. 224,290, June 11, 2018. Note: jurisprudence dictates that the procedure enshrined in Section 21, Article II of RA 9165 is a matter of substantive law, and cannot be brushed aside as a simple procedural technicality, or worse, ignored as an impediment to the conviction of illegal drug suspects. People v. Batista, Gr. No. 225,783, August 20, 2018, citing People v. Mukapundag, Gr. No. 225,965, March 13, 2017, 820 Scr 204, 215, further citing People v. Umapang, 686 Phil 1024 2012, at 1038. Foremost, the rule-making power of the court in matters of pleading, practice, and procedure in all courts is vested by Section 55, Article VII of the Constitution. Hence, being plenary in nature, the court cannot be called upon by a private citizen to exercise such power in a particular manner, especially through the vehicle of a petition for certiorari or prohibition, which is intended for an entirely different purpose. Mercado v. Lopina, Gr. No. 230,170, June 6, 2018. Note: the concept of SLAP, strategic lawsuit against public participation, was first introduced to this jurisdiction under the Rules of Procedure for Environmental Cases AM. No. 968 SC. As defined therein, a SLAP refers to an action, whether civil, criminal or administrative, brought against any person, institution or any government agency or local government unit or its officials and employees, with the intent to harass, vex, exert undue pressure or stifle any legal recourse that such person, institution or government agency has taken or may take in the enforcement of environmental laws, protection of the environment or assertion of environmental rights. In application, the allegation of SLAP is set up as a defense in those cases claimed to have been filed merely as a harassment suit against environmental actions. XXX. Transposed to this case, the court finds no occasion to apply the foregoing rules as the petition has no relation at all to the enforcement of environmental laws, protection of the environment or assertion of environmental rights. RA No. 9262, which involves cases of violence against women and their children, is not among those laws included under the scope of AM. No. 968 SCXXX. Mercado v. Lopina, Gr. No. 230,170, June 6, 2018. Note: SLAP, as a defense, is a mere privilege born out of procedural rules. Accordingly, it may only be exercised in the manner and within the scope prescribed by the court as a rule-making body. Here, petitioners cannot, under the guise of substantial justice, rely on a remedy that is simply not available to them. In fact, by invoking the court's rule-making power in their petition, petitioners have admitted that the instant action has no basis under any of the rules promulgated by the court. The court takes this occasion to remind petitioners that rules of procedure are not a one-size-fits-all tool that may be invoked in any and all instances at the whim of the litigant, as this would be anathema to the orderly administration of justice. Mercado v. Lopina, Gr. No. 230,170, June 6, 2018. Judges, according to the Republic, because respondent failed to fulfill the JBC requirement of filing the complete SALNs, her integrity remains unproven. The Republic posits that the JBC's ostensible nomination of respondent does not extinguish the fact that the latter failed to comply with the SALN requirement, as the filing thereof remains to be a constitutional and statutory requirement. If a candidate appointed despite being unable to comply with the requirements of the JBC and despite the lack of the aforementioned qualifications at the time of application, the appointment may be the subject of a quo warranto provided it is filed within 1 year from the appointment or discovery of the defect. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: when the Solicitor General files a quo warranto petition in behalf of the people and where the interests of the public is involved, the lapse of time presents no effective bar. A quo warranto action is a governmental function and not a proprietary function, and therefore the doctrine of laches does not apply. Indeed, when the government is the real party in interest, and is proceeding mainly to assert its rights, there can be no defense on the ground of laches or prescription. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: the Republic cannot be faulted for questioning respondents' qualification for office only upon discovery of the cause of ouster. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: as will be demonstrated hereunder, respondent was never forthright as to whether or not she filed her SALNs covering the period of her employment in UP. XXX. Even up to the present, respondent has not been candid on whether she filed the required SALNs or not. XXX. Hence, until recently, when respondent's qualification for office was questioned during the hearings conducted by the House Committee on Justice on the impeachment complaint against the respondent, there was no indication that would have prompted the Republic to assail respondent's appointment, much less question the wisdom or reason behind the said recommending and appointing authorities' actions. The defect on respondent's appointment was therefore not discernible, but was, on the contrary, deliberately rendered obscure. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: on another point, the 1-year prescriptive period was necessary for the government to be immediately informed if any person claims title to an office so that the government may not be faced with the predicament of having to pay two salaries, one for the person actually holding it albeit illegally, and another to the person not rendering service although entitled to do so. It would thus be absurd to require the filing of a petition for quo warranto within the 1-year period for such purpose when it is the state itself which files the same, not for the purpose of determining who among two private individuals are entitled to the office. Stated in a different manner, the purpose of the instant petition is not to inform the government that it is facing a predicament of having to pay two salaries. Rather, the government, having learned of the predicament that it might be paying an unqualified person, is acting upon it head-on. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: most importantly, urgency to resolve the controversy on the title to a public office to prevent a hiatus or disruption in the delivery of public service is the ultimate consideration in prescribing a limitation on when an action for quo warranto may be instituted. However, it is this very same concern that precludes the application of the prescriptive period when it is the state which questions the eligibility of the person holding a public office and not merely the personal interest of a private individual claiming title thereto. Again, as we have stated in the assailed decision, when the government is the real party in interest and asserts its rights, there can be no defense on the ground of laches or limitation. Otherwise, it would be injurious to public interest if this court will not act upon the case presented before it by the Republic and merely allow the uncertainty and controversy surrounding the Chief Justice position to continue. Republic v. Sereno, Gr. No. 237428, Resolution on the motion for reconsideration, June 19, 2018. The qualifications of an aspiring member of the Supreme Court are enshrined in Section 7, Article VII of the Constitution. XXX. Evidently, more than age, citizenship and professional qualifications, our fundamental law is clear that a member of the judiciary must be a person of proven competence, integrity, probity and independence. XXX. Emphatically, integrity is not only a prerequisite for an aspiring member of the court but is likewise a continuing requirement common to judges and lawyers alike. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Failure to file the SALN is clearly a violation of the law. The offence is penal in character and is a clear breach of the ethical standards set for public officials and employees. It disregards the requirement of transparency as a deterrent to graft and corruption. For these reasons, a public official who has failed to comply with the requirement of filing a SALN cannot be said to be of proven integrity, and the court may consider him/her disqualified from holding public office. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Such failure to file and to submit the SALNs to the JBC is a clear violation not only of the JBC rules, but also of the law and the Constitution. The discordance between respondent's non-filing and non-submission of the SALNs and her claimed integrity as a person is too patent to ignore. For lack of proven integrity, respondent ought to have been disqualified by the JBC and ought to have been excluded from the list of nominees transmitted to the President. As the qualification of proven integrity goes into the barest standards set forth under the Constitution to qualify as a member of the court, the subsequent nomination and appointment to the position will not qualify an otherwise excluded candidate. In other words, the inclusion of respondent in the shortlist of nominees submitted to the President cannot override the minimum constitutional qualifications. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Note: the effect of the finding that a person appointed to an office is ineligible therefore is that his presumably valid appointment will give him color of title that confers on him the status of a de facto officer. Republic v. Sereno, Gr. No. 237428, May 11, 2018. Respondent insists that the filing of SALNs bears no relation to the constitutional qualification of integrity. For her, the measure of integrity should be as what the JBC sets it to be, and that in any case, the SALN laws, being malum prohibitum, do not concern adherence to moral and ethical principles. Respondent's argument, however, dangerously disregards that the filing of SALN is not only a requirement under the law, but a positive duty required from every public officer or employee, first and foremost by the Constitution. The SALN laws were passed in aid of the enforcement of the constitutional duty to submit a declaration under oath of one's assets, liabilities, and net worth. This positive constitutional duty of filing one's SALN is so sensitive and important that it even shares the same category as the constitutional duty imposed upon public officers and employees to owe allegiance to the state and the Constitution. As such, offences against the SALN laws are not ordinary offences but violations of a duty which every public officer and employee owes to the state and the Constitution. In other words, the violation of SALN laws, by itself, defeats any claim of integrity, as it is inherently immoral to violate the will of the legislature and to violate the Constitution. Republic v. Sereno, Gr. No. 237428, Resolution on the motion for reconsideration, June 19, 2018. For lack of a constitutional qualification, respondent is ineligible to hold the position of Chief Justice and is merely holding a colorable right or title thereto. As such, respondent has never attained the status of an impeachable official, and her removal from the office, other than by impeachment, is justified. The remedy, therefore, of a quo warranto at the instance of the state is proper to oust respondent from the appointed position of Chief Justice. Republic v. Sereno, Gr. No. 23748, May 11, 2018. The present is the exigent and opportune time for the court to establish well-defined guidelines that would serve as guideposts for the bench, the bar and the JBC, as well, in the discharge of its constitutionally mandated functions. In sum, this court holds: quo warranto as a remedy to oust an ineligible public official may be availed of, provided that the requisites for the commencement thereof are present, when the subject act or omission was committed prior to or at the time of appointment or election relating to an official's qualifications to hold office as to render such appointment or election invalid. acts or omissions, even if it relates to the qualification of integrity being a continuing requirement but nonetheless committed during the incumbency of the validly appointed and/or validly elected official, cannot be the subject of a quo warranto proceeding, but of impeachment if the public official concerned is impeachable and the act or omission constitutes an impeachable offense, or to disciplinary, administrative or criminal action, if otherwise. Members of the judiciary are bound by the qualifications of honesty, probity, competence, and integrity. In ascertaining whether a candidate possesses such qualifications, the JBC, in the exercise of its constitutional mandate, set certain requirements which should be complied with by the candidate to be able to qualify. These requirements, as well as subsequent changes thereto, are announced and published to notify not only the applicants but the public as well. Changes to such set of requirements, as agreed upon by the JBC and bank through a proper deliberation, such as in this case when the JBC decided to allow substantial compliance with the SALN submission requirement, should also be announced and published for the same purpose of apprising the candidates and the public of such changes. At any rate, if a candidate appointed despite being unable to comply with the requirements of the JBC and despite the lack of the aforementioned qualifications at the time of application, the appointment may be the subject of a quo warranto provided it is filed within 1 year from the appointment or discovery of the defect. Only the Solicitor General may institute the quo warranto petition. The willful non-filing of a SALN is an indication of dishonesty, lack of probity and lack of integrity. More so if the non-filing is repeated in complete disregard of the mandatory requirements of the Constitution and the law. Consistent with the SALN laws, however, SALNs filed need not be retained after more than 10 years by the receiving office or custodian or repository unless these are the subject of investigation pursuant to the law. Thus, to be in keeping with the spirit of the law requiring public officers to file SALNs to manifest transparency and accountability in public office, if public officers cannot produce their SALNs from their personal files, they must obtain a certification from the office where they filed and/or the custodian or repository thereof to attest to the fact of filing. In the event that said offices certify that the SALN was indeed filed but could not be located, said offices must certify the valid and legal reason of their non-availability, such as by reason of destruction by natural calamity due to fire or earthquake, or by reason of the allowed destruction after 10 years under Section 8 of RA No. 6713. Republic v. Sereno, Jr. No. 237428, May 11, 2018. Note: accordingly, the court, on the basis of an 8-6 vote, ruled that the respondent is found disqualified from and is hereby adjudged guilty of unlawfully holding and exercising the office of the Chief Justice. Accordingly, respondent Maria Lords P.A. Sereno is ousted and excluded therefrom. Republic v. Sereno, Jr. No. 237428, May 11, 2018.